Hi, everyone. So I'm going to go ahead and get started, but I did want to give a few housekeeping rules, just a little bit. Um, if you have a question, feel free to put your hand up. I'll do my best to look at the chat, or you can unmute yourself and just ask a question. Feel free to stop me. So welcome everyone. My name is Yashika DeBerry, and I'll be delivering a presentation today on behalf of SCORE. So a little bit about me. I am an HR consultant, or I guess an HR professional. I've been working in the field of HR for 20 years, and I'm still truly passionate about it. That may be weird, but I am. What I'm more passionate about is helping business owners to have the tools needed to be successful in the realm of HR. Um, so today, here's what we'll be diving into. We'll be talking about the importance of employment law compliance with small business owners. I'll first go over the key federal laws. I won't go over all of them because there's a ton. I'll go over the key federal employment laws, and then I'll go over the state employment laws that are relevant to Florida. My goal when you walk away from this webinar is to ensure that you understand the laws at the federal and the state level, and you're able to have at least a starting point of taking the appropriate steps to ensure you're in compliance and you're mitigating risk for your business, okay? Um, all right, let's go ahead and get started. So some of you may say, like, what do these laws have to do with my business? Why should I even care? This is what I specialize in. Why should I care about law? Well, ignoring employment laws can be a ticking time bomb waiting to explode. Violating regulations can lead to like hefty fines, lawsuits, and even criminal charges. Those are all things that we don't want when we're building a business. It's so hard to build a business. And the last thing you want is for someone to come in and sue you, or you have to pay fines and take money out of your business that could be helping you to grow bigger and larger, right? These violations can not only drain your financial resources, but also damage your reputation and hinder your ability to attract and retain talent. So, by complying with employment laws, you significantly reduce these risks and ensure that your business is operating smoothly and legally. So keep in mind that complying with employment laws isn't just about, avoiding fines and penalties, but when you build a business, you want the best people on your team. And how you do that will be through your reputation, how your business speaks for you. And that will put you in a position to be able to attract top talent, but not only just attract them and have them to come and work for your company, but keep them retained and reduce turnover while ensuring a stable and productive workforce for your company. Okay. So, as I said before, the next few slides that I'll go over will introduce key federal laws. These laws, they set basic standards for workplace practices like anti-discrimination, minimum wage, disability accommodations, and family leave. Okay. And all of these laws are like based on core principles that will be essential for you as a business owner. All right, so we've got this chart here that shows the federal employment laws. Like I said, while there are a wealth of employment laws that are driven by a business's employee headcount, today I'll just review with you the key employment laws to be aware of as a business owner. I would put you all to sleep if I told you about all of the laws that were out there. So I will be nice and not bore you. Um, so up first, we have the FLSA, the Equal Pay Act, OSHA, something called ICRA, and ERISA. These are a lot of acronyms. I will spell them out for you so you know exactly what they stand for. But these all apply to all employers, no matter if you have one employee or 500 employees. These laws cover core worker protections like minimum wage, overtime pay, safety standards, immigration verification, and retirement benefits. And then if you take a look at the chart, we have Title VII and something called ADA. the American with Disabilities Act. They apply to businesses that have 15 or more employees. These laws prohibit discrimination based on race, color, religion, sex, national origin, disability, and other protected characteristics. And then you have FMLA, the Family Medical Leave Act, which applies to businesses that have 50 or more employees who are located within a 75-mile radius of where your business is located. The FMLA mandates that you provide unpaid leave for qualified medical or family reasons for your employees while providing them with job protection, meaning that they go out on the leave, they're able to come back, but they still have a comparable job to come back to. Now, I feel like I just said a mouthful, and I want to take a pause before I move on to the next page and see if there are any questions about what I've gone over so far. Any questions? If there are no questions, I'll keep moving forward. All right. So up first, we have the Title VII of the Civil Rights Act, which was signed in 1964. And it was put into place to prohibit discrimination in the workplace based on protected classes. But before we move on, I think it's important to define exactly what a protected class is. Um, so, a protected class is defined as a group of people who share a specific common identity or characteristic and who are legally protected from discrimination on the basis of that characteristic. If you look down at the bottom of the slide, it shows the actual protected classes. We have race. This is defined as color, um, well, not defined, but it includes color, ancestry, and national origin. And then there's color, any skin tone or complexion. There's religion, which addresses an individual's sincerely held beliefs and practices, including like observance of any religious holidays or maybe like a certain dress code or headdress that someone may wear. And then there's sex. This includes biological sex, gender identity, and sexual orientation. And then we have national origin, where it talks about or covers an individual's country of origin or ancestry, including their cultural background or language. Any questions about protected classes? Okay. All right. So as you can see, Title VII applies to all aspects of employment, including hiring, firing, promotions, compensation, training, and even workplace conditions. So I think it would be good for me to share some examples of some things that would violate Title VII. Okay. So, say for instance, you interviewed several candidates, you found one, or you finally made a decision and you issued a job offer to this person. And they told you in a conversation in passing when you were giving the offer that they practice X religion. You, as an employer, you do not want to have any association with said religion. So you decide to now pull the job offer back. That would be considered discrimination. Another example could be you decide to hire someone or you're hiring men and women, and you decide to pay all of your women a lower pay or give them less promotions than the men who are doing the same work. That would be considered discrimination. Or maybe you're terminating an employee because you found out that they have ADHD and they're not able to focus, and you didn't take the time out to see how you could help them while they would still be able to do their job. Discrimination. Um, or maybe you have someone in your company that tells harassing jokes or offensive jokes, and they're based on, say, like race or someone who's of a certain ethnicity. That would be considered discrimination. All of those examples would violate Title VII of the Civil Rights Act. Okay. Um, as you can see, Title VII does play a crucial role in fostering a fair and inclusive workplace by understanding protected classes, what they are and how they apply in your industry, you can put yourself in a position as a business owner to prevent discrimination and comply with the laws. You also, by complying with Title VII of the Civil Rights Act, you also put yourself in a position to create a work environment that is diverse and one where you're mitigating legal risk. So, up next, we have the Fair Labor Standards Act. This act was established in 1938, and it's considered to be a cornerstone of worker protection in the United States. Think about the work environment prior to 1938. It was totally different from how it is now. And it's also known as the FLSA. It applies to most public and private sector employees, but there are some exemptions. We'll cover those later. The core objectives of the FLSA is to improve working conditions and to prevent unfair labor practices. This federal law covers minimum wage, it covers overtime pay, it covers record keeping requirements, and it also covers child labor protections. So let's take some time and go over each of those coverage areas. So as it stands right now, the minimum wage at the federal level is $7.25 per hour. And while our state's minimum wage is higher than the federally mandated minimum wage, employers are always required to comply with the higher rate. So if for some reason the federal rate was higher than our state's, you would need to comply with the federal. The FLSA also governs overtime. And to understand who qualifies for overtime, let's first define what it is. Overtime refers to any hours worked by a non-exempt employee that exceeds their normally scheduled working hours in a 40-hour work week. Individuals, non-exempt employees are covered by the FLSA Act, and it says that they must receive overtime pay for hours worked over 40 in a work week at a rate not less than time and a half, their regular rate of pay. For instance, if you have an employee where you're paying them $10 an hour for their regular base rate, $10 an hour, and they work overtime, this means that their overtime rate would be $15 an hour in the state of Florida. By the way, do I have anyone on the call that isn't an employer, that may be an employer in another state, or are you all employers in the state of Florida? Okay. And the reason why I'm asking is because different states have different rules about overtime. In Florida, overtime is considered any hours over 40 in a work week. However, in places, say like California, it's any overtime is considered any hours over 8 hours a day each day. So there's a difference when it comes to states. Most states are like Florida, but there are some that are different. And that's why I wanted to kind of point that out. Okay. So if you have employees in other states, but you're based here in Florida, that may be something to think about. They would be eligible for the overtime requirements based on the state of their residence. All right. There is no limit in the FLSA Act on the number of hours employees age 16 or older may work in any work week. However, the FLSA does not require overtime pay for work on Saturdays. Okay. Now let's review the difference, and thank you for the question, Antoinette.
You're welcome.
Let's review the difference between non-exempt and exempt employees. Okay, so if you take a look at the chart here, we have exempt employees and then we have non-exempt employees. These two classifications determine whether someone will be eligible for overtime or not. In exempt positions, these positions typically have specific duties outlined by the FLSA and often have a fixed salary regardless of hours worked. Common examples include executives, managers with supervisory duties, computer professionals, and outside sales personnel. One thing I do want to point out, it isn't just about the job title, but it has mostly to do with whether there's something called the duties test, whether they meet the requirements under the FLSA, and also the nature of their role. Some of the things when we're looking at whether someone is exempt or non-exempt is understanding their ability to their decision-making ability, their ability to work autonomously. Do they take direction from someone and then do their work, or do they just come in and they know what to do, and what they do is driven by whatever they know they need to do? It just depends. And then there are non-exempt employees. These positions usually receive an hourly rate and are entitled to overtime pay after exceeding 40 hours in a work week. Most hourly workers include, some examples include like cashiers, servers, construction workers, administrative assistants. But again, it is not just about the title, it is about the nature of their role, decision-making ability, and several other factors. Keep in mind that small businesses often misclassify employees, which can lead to significant fines and back pay penalties. One of the best practices I can share with you, if you are ever undecided, I mean, if you are ever unsure, well, you want to talk to an employment lawyer, or you want to reach out to an HR consultant who can walk you through that and help you classify those positions. But it best practice, if you don't have anyone in your corner to help you, your best bet is to always make the person hourly, because it would capture overtime. And if for some reason you needed to reclassify them later on, you've pretty much played it safe. But I would say all in all, you should definitely like have your roles reviewed and make sure you understand the specific criteria as to whether someone is exempt or not, so you can avoid that. Okay. So another part of the FLSA is the accurate record keeping. As an employer, you are required to maintain accurate records of all employee hours worked, including regular and overtime hours. These are for individuals that would be hourly. Um, you want to utilize, you can utilize a timekeeping system or you can utilize paper. It just depends on what resources you have and what you can afford. Some of these things get really pricey, and if you're just starting out, you want to minimize that cost a bit. So you can have them to have their write their starting time, their end time, record overtime hours. You want to make sure they have a pay stub. And the reason for this is because if an employee went to the Department of Labor and filed a wage and hour claim, you as an employer would be required to solidify or um, refute what the employee is claiming. If they said, I never got paid for my hours, you should be able to pull out accurate records and show actually they did, and here's what they received, here's what they work. So it's important to keep documentation as much as you can, okay? Another part of the Fair Labor Standards Act would be child labor. I won't go into this in depth. I'll just touch on it. I do plan to share a document with you all where you can read more about more of this information, but this webinar is a starting point for you. So the Fair Labor Standard Act also covers child labor, and it aims to protect children from exploitation and ensure their educational opportunities, meaning you can offer for have them to be able to work, but they need to be doing things that are safe. They can only work a certain amount of hours when they're in school. It varies by state, but I'll share more information on that just so you are aware. But the FLSA governs what they can do, what they can't do, where they can work, and how much they can work. So let's move on to the Equal Pay Act. Um, The Equal Pay Act mandates equal pay for equal work regardless of an employee's sex. This applies to all forms of compensation, including salary, hourly wages, bonuses, commissions, and more. It covers any employee in any status, full-time, part-time, temporary, and the goal is to ensure fairness across the entire workforce. Now, keep in mind that not all pay differences violate the Equal Pay Act. If you have a legitimate variation reason for variations, and say it's based on seniority or merit or production-based systems or any other bona fide factor unrelated to sex or protected class, those are permitted, but you do need to keep good records as to why maybe Mary has a higher salary than Tim when they're doing the same job, or whatever it may be, that Tim got a promotion and Mary didn't, although their backgrounds and their how they work looks the same. You want to keep that in mind, making sure that it is objective and their actual bona fide reasons for it. Okay. If for some reason you're unsure about that, you can always connect with an employment lawyer or an HR consultant, and they can help you with something called a pay audit. Someone like myself or an employment lawyer, if you have one, they can go in, take a look at the pay, do a consensus, and look at male versus female, look at tenure, and understand like if there are any discrepancies that maybe you just aren't aware, and help you to clarify those. All right. Now let's move on to the Occupational Safety and Health Act. You probably know it as OSHA. Um, OSHA was established in 1970, and their mission, when they started and even to this day, was to ensure safe and healthful working conditions for all employees. OSHA covers most private sectors, their employers and their employees, and some public sectors in specific jurisdictions. This means that your business likely falls under OSHA's purview, regardless of its size or industry. Okay, let's dive in and talk about OSHA a little bit more. So there are three key activities that OSHA does. Um, and that includes a standard setting. OSHA was put in place to establish comprehensive standards that address workplace hazards, whether we're talking about chemical exposures, to falls, electrical dangers. It just depends, and it varies across different industries. OSHA is also known as an enforcer, so they are tasked with conducting inspections to ensure compliance with these standards and taking action against violators. And then OSHA is also, you can also consider them to be a resource if you want to be really proactive in your organization. If you go to their website, you'll see several resources and training programs that you can take advantage of for you and your employees, so you can learn about the best safety practices. I'll give you guys a really good example of something that OSHA could handle. I took my dad, he was visiting the other day, and he needed a new phone. He broke his phone at the airport, and we went to a phone store. I won't, a cell phone store. I won't tell you where it was, but when we walked in the store, it was like, it was really hot. I could tell. I had on a sweater, took my sweater off, and I was like, is the air on? And the representative said, no, the air's been out for about a month. And I looked at the setting for the air, and it said 84 degrees, and he was really hot. And I said, this is something that you can report, not to get your employer in trouble, but you may want to think about that. Are they providing you like with any water or anything, just to make sure you don't get dehydrated in the store? And he said no. Employees can reach out to OSHA and submit anonymously things that may be happening at an employer. Say there isn't running water or a um, restroom facility to use, they can report those things. So you want to be careful about that, because they can result in penalties. So as an employer, you definitely want to be creating a safe and productive work environment. So let's go ahead and talk about the next federal law. The Employee Retirement Income Security Act, also known as ERISA. The ERISA Act was enacted in 1974, and it sets the minimum standards for most employer-sponsored retirement plans, whether it be 401(k), a pension, whatever it is. It is an area of employment law that is heavily regulated because there were several things that happened in the past, and um, this is where we ended up landing due to past, history. So under ERISA, business owners are required to ensure like any plan that you offer, it meets all reporting, disclosure, and fiduciary requirements. It requires you as a business owner to act in the best interest of plan participants when making investments and decisions. It also requires you to provide clear and timely information about the plan's terms and benefits. I don't know if you've had a 401(k) plan somewhere else. You may have noticed that you get several updates about changes to the terms and conditions. Retirement plans, they are required to share that information and share it within a certain time frame. Otherwise, they won't be in compliance. And as an employer, if you go down that route of offering a retirement plan, you definitely want to make sure you're working with whoever's offering the plan, whether it's Vanguard or whoever it may be. They will help you with the compliance piece of it, but you have to make sure you're complying. Non-compliance can include financial penalties, lawsuits, potential loss of tax benefits that you receive by putting a retirement plan in place. But most of all, your employees won't trust you and, their morale will drop. Okay. Um, okay, Melanie, are you taxed for starting a retirement plan? Actually, when you start a retirement plan, you actually receive tax benefits where you receive some tax cuts. I can share more information on that. I don't have the specifics right now, but it's actually more of a benefit to you than for you to, it's not necessarily a debit, it's more so a credit to you by offering that plan. That's why many employers actually go in and start offering a retirement plan. One, because they want to offer good benefits to their employees, but also because it is a good tax benefit to small businesses. Any other questions about the ERISA Act? All right. So up next, we have the Immigration Reform and Controlled Act. It's also known as the IRCA. Um, this federal law was put into place in 1986, and it addresses both immigration and employment. The act prohibits employers who knowingly hire undocumented workers. Under the IRCA, the I-9 verification process is also mandatory for all new hires. Um, this act also prohibits discrimination against authorized workers that maybe weren't born here in the US. They can still work for a US company as long as they have the proper documents and they can show them. Now let's talk about your responsibility as an employer. Under the IRCA and for the I-9 process, you will need to verify the work authorization of all new hires using Form I-9 and retain documentation within 3 days of the new hire starting work. You don't want to do this until after an offer is provided to the employee. Mainly on day one, they can fill out the I-9 prior to them starting, but it has to be after after they sign the offer letter. You will need to avoid discriminating against authorized workers based on their immigration status. So if someone comes from Mexico and you say, well, I don't want to hire them because they're a Mexican, that's not okay. That is a violation and it is discrimination. And you are required to maintain accurate records of the employment verification process. Let's take a look at the forms you will need to use. And I'm paying attention to the chat if you see me looking over here just to make sure there are no questions. So what you see here is a snippet of the I-9 form, but new hires are required to complete Section 1 on their first day of employment, and they have until the third day of employment to fully have it completed. Um, and provide you with documents from what we call a list of acceptable documents. So they would go in and complete section 1, and then they would turn this document into you with their list of acceptable documents. Here's what the list of acceptable documents look like. The employee may submit one document from list A or one document from list B and C. Best practice is to not tell the employee or the new hire what they should submit. For instance, if you tell all of your new hires, just bring your driver's license and social security card, that could be seen as an attempt to discriminate against the new hire, especially if they aren't born here in the US. They may not have a driver's license or a social security card, but they can choose one item from list A or one item from list B and C. And you just give this to them when they're filling out their new hire paperwork, and they need to bring these actual documents to you and show you the originals of the documents. Okay. I want to go back to the I-9 part, just the form, just for a moment, because there are penalties and fines if you don't do this process. But in addition to that, if you fill out this form incorrectly, when an auditor shows up to your place of employment, you can be fined for errors that are on the document. So you want to make sure you have a really good understanding of how to fill this document out and how you store it. If you go to the US Citizenship and Immigration Services site, they offer free trainings all the time where you can take the training and understand how to fill this form out, what the requirements are. There's a wealth of information out there, and I'll share that link with all of you. Okay, all right, I'm gonna go ahead and move forward. All right, so we have the Americans with Disabilities, also known as ADA. It applies to employers that have 15 or more employees. This includes state, local governments, employment agencies, and labor unions. The ADA protects qualified individuals with disabilities from discrimination and requires reasonable accommodations. So before we dive in, let me define the word disability. So a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. Um, it can cover a wide range of conditions, including vision and hearing impairments, mobility impairments, chronic illnesses, learning disabilities, mental health conditions. So this is just a short list, but it could be any of these or more. Um, so as an employer, if someone comes to you and says, um, I've had some people come to me and say, I have a hard time following when we're in meetings, can we record the meeting because I have ADHD, or can you send out a follow-up note? Me sending out a follow-up note to the team or recording like a meeting would be considered an accommodation. Accommodations, when an employee comes to you about something, it should be reasonable and it should allow the employee to still be able to do the work that they were hired to do. If it is not reasonable and it presents a burden to your company, then you may not be able to do it. But what the law requires is that you engage in something called an interactive process, meaning you're asking questions, you're trying to understand what they need. If they ask for 4 days off out of 5, that's a burden. You wouldn't be able to do that, but you could say, maybe you need to take a leave of absence, or I can do 1 day, but not 4. So those, keep in mind, those are all things that you need to be aware of and that you should attempt to try to make an accommodation. But if you can't, you should document why you can't and maybe offer an alternative. Um, all right. Well, I am going to jump into our Florida laws, and there are just a few of them. So I'll use the last 9 minutes to go over these. So they include our Florida Civil Rights Act, our Florida Minimum Wage Act, the Whistleblower Act, and the Equal Pay Act. The one that I won't go over again is the Equal Pay Act because it's pretty much the same as the federal one. So let's go ahead and jump in so you know about your state laws. So the Florida Civil Rights Act is also known as the FCRA Act. It was put in place in 1992. Truth be told, that's not that long ago. Um, and it plays a crucial role in ensuring fair and equal treatment for all employees in Florida. It has a broader protection than Title VII based on the federal laws, where it also in Florida, it also includes age, disability, and marital status as a protected class, as protected classes. Understanding the FCRA is essential for all Florida employers to avoid costly legal issues and create a truly inclusive workplace. So here's some things that you can do to ensure that you're complying with the Florida Civil Rights Act. One of the things I tell all employers is no matter what size they are, develop and implement written policies, i.e. your employee handbook. By doing that, you're creating and putting in place for everyone in your company to see comprehensive policies that talks about prohibiting discrimination. It talks about protected classes. It provides your employees with a guide around what's acceptable, what's not, what's legal, what's not. And everyone has an understanding and they can be consistent in what the requirements are as an employer and an employee at an organization. You would also want to develop a complaint process. In the state of Florida, we talk about the Whistleblower Act, and we'll go over that a little bit more. It's a good idea to establish a way for employees to submit concerns, whether it be like an inbox, if there's discrimination, they should be able to reach out to someone. And then when you receive those, even if you know it's from your problem child employee, you still want to investigate all complaints promptly and thoroughly. Because one of the things we know in the world of the workplace, two things can be true at the same time. Um, and then another example of something that you can do to make sure you are complying with the Florida Civil Rights Act is maintaining accurate records. We talked about that. For instance, if you interview some folks, you want to keep interview notes. So if someone came back and said, well, she didn't hire me because I'm a minority, you can go back and look at your notes and you can say, actually, I didn't hire this person because I didn't have a really good understanding of whether they would be able to do the job. They didn't give any examples, and this is why I hired this person. So that's just a really good example, okay? We talked about the Federal Minimum Wage Act, but there's also the Florida Minimum Wage Act. It was established in 2000, and as of September 30th of last year, the minimum wage went to $12 an hour. That is higher than the federal minimum wage. And it doesn't matter based on employee count. The minimum wage applies to every employer, regardless of the number of employees. Um, I want to go here and show you this. Here is a chart that shows the minimum wage as of 2023, but in September of this year, it will go up to $13. And then it will continue to go up until it's $15 an hour. Okay. Um, keep this in mind when you are hiring. It does apply to, your regular workers, not necessarily contractors, but you want to keep in mind what the minimum wage is. This is something that changes on a regular basis, and you need to be in line with this, okay? Um, Financial penalties for not complying with the Minimum Wage Act. There can be liquidated damages, meaning that you would have to pay unpaid wages owed to the employee, and you could also put yourself in a position to pay double the unpaid wages, attorney fees, or even civil penalties. So just don't do it. Make sure you know the minimum wage and you pay it accordingly. So The Florida Whistleblower Act, this was put in place in 1986, and it basically provides protection for employees who report suspected violations of law, rules, or any regulations that may be happening within their employer's workplace. It covers public and private sector employees in various industries. And basically, an employee has the right to submit a complaint or concern, knowing that there won't be any retaliation for them reporting wrongdoing. So let's quickly talk about what can be reported. So they can report like violations of a law. Remember the guy at the phone store I told you about where they're not cooling his place of employment. He can report that. He didn't want to, but he could. It could be discrimination or harassment or concerns about potential dangers to public health or safety. So there are several ways that you can start a whistleblower program within your company. You can lead the way by creating an environment for people to speak up at all times. You can create a reporting program and do that through like a confidential email or inbox or anonymous hotline. You can implement policies, making sure people know that there will be no retaliation. And when you create such a program, you want to make sure there's more than one, if possible, you want to make sure there's more than one person that they can report it to. And I talked about the Equal Pay Act. I won't go over that, but that concludes all of the employment laws. Hopefully, you have a really good understanding of all of the laws that we've gone over. If you have your phone with you right now, you are absolutely welcome to scan this QR code. But if you want to get access to all of the information I went over, you can scan that QR code and it will take you to a Google Doc where you can download that sheet for yourself. And I'm going to go back and put it here. In addition to this, if you would like to reach out to me, you're absolutely welcome to contact me here. That QR code you can scan and you'll get my contact information. I will say this, I want to thank you all for participating in this webinar. I'm so glad that I was able to share some knowledge with you today, and I will be following up in an email and provide the information. If you have any other questions, reach out. I'm always eager to help other business owners, and I definitely wish you the best and success as you continue to build your business. All right. Thank you all so much for a great session, and I hope you have a great day. Bye, everyone.